But so what about the constitutionality of this?
Well, I said that there were three problems earlier, and they have to be analyzed in two ways. First is whether or not the statute even permits this to happen. And it's not clear that it does. It really depends on how you interpret the statute. But secondly, if it does permit this to happen, does it present a constitutional problem? Now, it is current law that there is no constitutional right not to be vaccinated. There was a Jacobson case, which was decided in 1905, which upheld a fine that was imposed on, somebody who didn't comply with a vaccine mandate in Massachusetts. And, unless the Supreme Court reverses itself, there's no liberty interest. There's no freestanding constitutional right not to be vaccinated. You've got to be vaccinated to go to schools. You've got to be vaccinated against the measles. But there's still a constitutional problem. And the constitutional problem is that is called the non-delegation doctrine. And the non-delegation doctrine has been largely dormant for most of the past 70 or 80 years. But it basically says that if Congress wants to give power to an administrative agency like OSHA, it has to be specific. It has to give specific directions. That some general command to do good or to promote safety is not enough. And courts have been very, very reluctant to enforce that, to strike down agency actions. There is some indication recently that a majority of the Supreme Court is willing to reconsider that, and this may be the occasion for them to do so. And the idea is that in our system, Congress makes the law, not the president, not administrative agencies. The president and administrative agencies enforce the law. And if Congress doesn't provide adequate direction, if it just says, go out and do good, it has delegated its legislative authority. It has given its legislative authority to an executive officer. And under our separation of powers, we have the executive, the legislature, the judiciary. That is constitutionally impermissible.